Now we will be discussing the special provisions pertaining to the Union Territory of Puducherry. Earlier, Puducherry was known as Pondicherry. After the 20th of September 2006, it is now retained its earlier Tamil name, which is Puducherry. Now, the French had given Puducherry the new name Pondicherry. This is why there are certain special provisions with respect to Puducherry in the Constitution of India. After the Constitution 14th Amendment Act 1962, Article 239A was inserted into the Constitution. Now, Article 239A provides that the Parliament may by law provide for a legislature for the Union Territory of Puducherry or Council of Ministers or both with such powers and such functions as it may deem fit. Hence, the legislature of Puducherry may be established by Parliament by law. However, the power of Parliament to still legislate for the Union Territory of Puducherry is retained. Hence, if there is any discrepancy or any clash between the law made by Parliament on one hand or the law made by the legislature of Puducherry on the other hand, the law made by Parliament will prevail. However, if the law made by the state legislature, the Union Territories legislature, is assented to by the President, then in that case, that law will prevail over the parliamentary law. Now, the Government of Union Territories Act 1963 was passed by the Parliament in pursuance of powers vested under Article 239A. Now, this particular enactment provides for the Parliament to establish for the Union Territories, for certain Union Territories, the legislature or Council of Ministers or both. However, it is to be noted that since Article 239A deals with only Puducherry, in that case, the Government of Union Territories Act 1963 will deal with only Puducherry. Now, the legislature for the Union Territory of Puducherry as well as the Council of Ministers have been established under this particular enactment. The legislature of the Union Territory of Puducherry has the power to legislate upon any of the entries in List 2 or List 3 of the 7th schedule of the Constitution. Now, in that case, this means that the legislature of the Union Territory of Puducherry will have power to make laws with respect to any of the entries in either of the lists, whether it is List 2 or List 3. In addition, there is a Council of Ministers with Chief Minister at the top to aid and advise the administrator of the Union Territory of Puducherry. The administrator of the Union Territory is now designated as the Lieutenant Governor of Puducherry. Now we will be discussing the President's power to make regulations for certain Union Territories. Article 240 of the Constitution provides that the President shall have the power to make regulations for the peace, progress and good governance of the Union Territories. This power of the President is over and above the power of the Parliament to legislate for any of the Union Territories under any of the lists. However, wherever a legislature is established under Article 239A for the Union Territory of Puducherry, the President shall not have any power to make regulations for the Union Territory of Puducherry. However, there is a rider here. If the legislature, which is formed under Article 239A for the Union Territory of Puducherry, is dissolved or is in recess, then in that case, the President can make regulations for the peace, progress or good governance of the Union Territory of Puducherry. In T.M. Kannayan versus Income Tax Officer, Pondicherry as it then was, the question arose whether the President had the power to pass the regulation which was the income tax extension to Union Territories Regulation 1963, whether this was constitutional or not. Now in this case, the Supreme Court observed that the power given under 240 is wide and the President has the power to extend the Income Tax Act to the Union Territories under the regulation of 1963. It need not have any particular special permission for the President to be passing such a regulation. This was a landmark judgment which meant that under Article 240, President exercises wide powers. Now we shall be discussing the constitution of the High Courts of the Union Territories in India. Under Article 241, the Parliament has been given the power to constitute High Courts for the various Union Territories. Hence, the Parliament acting under 241 has either extended the jurisdiction of existing High Courts or made special High Court for particular Union Territories. And in this case, it is only in case of Delhi that a special High Court has been made. With respect to the Union Territory of Chandigarh, the Punjab and Haryana High Court exercises jurisdiction. With respect to Lakshadweep, the Kerala High Court exercises jurisdiction. With respect to Puducherry, the Madras High Court exercises jurisdiction, and the Calcutta High Court exercises jurisdiction over the Andaman and Nicobar Islands. And finally, it is the High Court of Bombay which exercises jurisdiction over the Union Territory of Daman and Diu in addition to Maharashtra and Goa. Hence, I would like to conclude by saying that Constitution of India provides certain special status to the Union Territories, and these are special units which have been kept outside the federal framework of India and hence have been given a special status under the Constitution due to various historic, cultural or political reasons. Thank you.